Hello students, welcome back to the channel. In today's video, we are going to discuss a very important and a landmark case relating to professional ethics. When you look at professional ethics syllabus, you will see that there are a lot many different cases which are listed down that you need to study. Now, studying these cases will be helpful for you not just to understand the subject but also to know the perspective of Bar Council of India, how cases are decided, what is considered as professional misconduct and what is not. The case that we will be discussing today is Bar Council of India Transfer Case 43 of 1982. So this case is filed before the Disciplinary Committee of Bar Council of India. When a person thinks that there is professional misconduct from a person from the legal fraternity, cases are registered before the Disciplinary Committee, whether you talk about the State Bar Council or Bar Council of India. So this case is S and H. There are two petitioners, S and H petitioners versus T, who is the respondent or the respondent advocate. The decision for this case came on 9th of July 1988. And now let's look at the brief facts of this case. So originally the matter was filed before Bar Council of West Bengal, but it could not be decided within the statutory period of 1 year. And as a result, the case got transferred before the Disciplinary Committee of Bar Council of India. Now why this matter was filed? First of all, the complainant said that I had engaged this particular lawyer for few of my cases, and because of this professional relationship as an advocate versus as a client, we had built a confidence over this person, and as a result what they did is the advocate took advantage of this confidence and the respondent gave an offer to the complainant number 1 and his wife and 2 others to enter into an agreement regarding bricks business. Because of this client and advocate relationship, they had gained confidence on the person, and the person gave proposal that let's start brick business wherein my wife will be involved along with 2 other people. Subsequently, they applied for trade license also because it was a trade practice, right? It was a business that they wanted to grow, brick business. So they obtained trade license also. It was applied for, and trade license was issued also in the name G&M, indicating Ghosh, Nath and Mondal as bricks manufacturing company. So they got the license as well. The respondent or the advocate, right? The advocate took money 18,496 from complainant number 1 as her share capital. The advocate's wife was involved in the business, so he said that as her share capital, he obtained this amount of money, 18,496 rupees. Though the brick business was carried on, no partnership deed was executed. It was a partnership between 3 people, right? They did not execute any such partnership deed or anything, but they just started with the business, brick business. They started with it. The respondent executed a partnership deed excluding complainant number 1 and his wife, Srimati K, suspecting the foul play and ill intention of the respondent. Complainant approached the respondent for redemption of accounts. At a later stage, partnership deed was executed, but one person was excluded from it, and he approached the advocate regarding it. However, the respondent refused for the same. He did not get any proper reply from the respondent advocate. And because of this confusion or because of this conflict that arose between them, the complainant approached the panchayat. And when they approached the panchayat, the respondent advocate, he agreed that yes, he had taken that amount of money as his wife's share capital. Thus, the subsequent acts of the respondent of excluding complainant number 1 and his wife from the partnership deed made it clear to the complainant that the respondent wanted to deceive and deprive them from the profits of the business, because all the 3 people were not added in the partnership deed. That indicated the evil intent of the advocate. Thus, the respondent misused power as an advocate who was enjoying confidence of the complainant as an advocate and their legal advisor. Right, so the complainant said that because he was engaged as an advocate and as a legal advisor because of the confidence they had built. Because of that only they had started with the brick business, and he has taken advantage of that particular position which has built because of the professional relationship. When the case was filed, the respondent advocate, he denied all the allegations. He said that there was just one criminal case wherein he was engaged, that too until bail stage only. Later on, the complainant had engaged another advocate. So it's not like they had a very long continuing professional relationship wherein he was acting as their legal advisor or dealing with all the legal cases of the complainant. It was nothing like that. He was just involved for one case, that too up to bail stage only. So the advocate said that I have not taken advantage of my position or anything like that, whatever allegations are being made. This was briefly about the facts of this case. Now let's look at question of fact and question of law. Whenever a case is filed before the court, there will be certain question of facts and certain question of law that the court tries to determine. Based on the facts of the case and based on what situation was there, these questions are being framed. Now for this particular case, what was the question of fact? Whether the respondent was involved in the brick business or not. So the disciplinary committee of Bar Council of India, after analyzing all the evidence and everything, concluded the answer in negation after going through the entire material on record and also hearing arguments of both the parties. They said that the person was not involved in brick business. The complainant did present some documents showing that the respondent advocate's wife was carrying on brick business, but that was not sufficient to prove respondent's involvement in the business, right? Because we are talking about professional misconduct of the respondent. So respondent was not involved in the business. As such, we cannot make him liable for that. There were certain documents which were presented by the complainant and it only showed that his wife was involved in that. So this was question of fact, and this is how Bar Council of India answered it in negation. Now what about question of law? Question of law is whether the respondent advocate is guilty of professional misconduct under section 35 of Advocates Act 1961. So the disciplinary committee of the Bar Council of India observed that there were no witnesses to prove the allegations made by the complainant or to establish professional misconduct on part of the respondent. Just because the advocate was a counsel for the complainant, which eventually resulted into a friendship might be amongst them, it would not mean that whatever act is done or whatever transactions happen between them, everything we will bring under the term professional misconduct, right? There might be certain dealings that might have happened between them, but it was not as a client and as an advocate relationship. So whatever other things would happen, everything we cannot bring under section 35 and call it as professional misconduct, just because once the person was engaged as a counsel to fight some of their cases. So this also was answered in negation, saying that this is not professional misconduct. So what was the judgment that was given by Disciplinary Committee of Bar Council of India? The complaint which was filed, it was dismissed as the complainant failed to prove any act of professional misconduct or other conduct within the meaning of section 35. Whatever happened, brick business, entering into partnership, taking share capital, it's not part of the person being engaged as an advocate and then dealing with his professional things, right? So Bar Council of India said that no, it is not professional misconduct under section 35 of the Act. So what observation we can make out of this is that just because an advocate is hired to fight a case, anything done thereafter cannot be brought within the purview of section 35 of Advocates Act. It actually has to be dealings because of professional relationship. So this was all about this case. I hope this case is clear to you. In case you have any queries, any suggestion, any feedback, do share that in the comment section below. Also, if there are any more cases that you want me to address, you can leave that as well in the comment section below.